Good afternoon, and welcome to the Klein DiNatale Goldner program, Returning to Work After Stay-at-Home Ends, HR Issues and Employment Law Compliance. Today's program is being sponsored by the following organizations: the Association of Builders and Contractors, Bakersfield Chamber of Commerce, Central Valley SHRM, Hispanic Chamber of Commerce, Kern County Builders Exchange, Kern County SHRM, and the Kern EDC. Today's program is being presented by Klein DiNatale Goldner's Jay Rosenlieb, Chair of the Labor and Employment Practice Group, and Donna Thrasher, Senior Human Resources Consultant. Attendees to today's program may submit questions by using the Q&A button located at the bottom of their screens. A recording of this webinar will be provided to all attendees in the next few days. We will now begin today's program.
Thank you, Molly, and good afternoon to all of you who have signed on to this webcast. My name is Jay Rosenlieb. I'm joined by my colleague, Donna Thrasher, and we're going to move quickly through the materials here to equip business owners and HR professionals to reopening their businesses following the stay-at-home orders and the various pronouncements from state and local government. What we will not be doing today is determining and discussing the rightness or wrongness of any particular orders. We will just simply take the orders as they are. I might also note that the information that you will be receiving today is current as of about 10 minutes ago, and that this is a matter that is evolving not weekly, not daily, but sometimes hourly and minute to minute. And so in that regard, we are going to focus on mostly nuts and bolts, but we are going to make some preliminary remarks as it relates to where we are in the reopening process. Donna, if you could go ahead and take us into that.
Absolutely. Good afternoon. Our governor, of course, on Monday said that some of our retail businesses could begin opening by the end of this week, and he will be giving further guidance right about now on the specific guidelines for those low-risk businesses to open as soon as tomorrow. Those retailers are supposed to include things such as clothing, books, music, toys, sporting goods, and florists just in time for Mother's Day. And they're going to be allowed to offer curbside pickup services and must institute safe guidelines. So we'll hear more about those shortly. And manufacturers who support those retail operations will be allowed to restart as well. That's not supposed to include offices, restaurants, or in-restaurant dining and shopping malls yet at this point. So in terms of reopening, there have been several phases identified, and of course we have been in phase one. We have all understood the stay at home, safer at home, unless you're a member of the essential workforce. We've been there in phase one. We're moving into part of phase two. We'll understand a little bit more about those non-essential retailers here shortly, and which ones of those can open here tomorrow. And then the second part of phase two doesn't seem like it's probably going to be happening this week. Hopefully it will be soon, but we don't know what timing is on restaurants and hospitality, and more broadly, modifications with school and child care and offices where remote work is not possible. So those are a latter part of phase two as we understand it currently. Phase three that we've all been waiting for, the hair and nail salons, the gyms, churches, movie theaters. Newsom has stated this is months away, but as we know, that changes by the hour. And then phase four is elimination of all restrictions, and there is no time estimate on that currently. And in terms of Kern County, The Kern County Public Health Department rescinded the local order on May 2nd around 6:30 in the evening. So we said, in Kern County, we don't have a different order than the state has, but we're still supposed to abide by the state orders. On May 4th, the governor did expand decision-making to the local level, and the Kern County Board of Supervisors, as recently as May 5th, said, please give us more latitude to open Kern County as it makes sense. So still clarifying exactly what the local level has authority to do and how they might attest to having the safe practices in place that are needed to get businesses going.
So, Donna, let's get sort of now into the issues that businesses, business owners, HR professionals are going to be confronted with, and that's actually bringing the employees back to work.
Yes, this is the good news, is getting some of those employees off of the unemployment, which may be easier said than done because unemployment's pretty lucrative and getting in the way of us getting some of our workers back. But as we plan to bring them back, think about how and when they'll return. Will they all return at once? Will some come in and then additional ones later? Make a plan. Use non-discriminatory factors for the recall selection. So if you don't bring them all back on day one, make sure that you are not discriminatory in how you make those selections.
This is a matter that sometimes is not as emphasized as much, and we certainly want to alert the folks on the call now to the fact that you're just as terminations are mass terminations are evaluated on the basis of disparate impact. Rehiring is going to be evaluated on the basis of disparate impact. So if you think that it's a good idea to bring back all the men before you bring back all the women because the men are the wage earners of the family and they need to support the family, you might consider that twice. All the recalls are going to be evaluated in terms of disparate impact.
Correct. And as we look at our high-risk employees, we need to create contingency plans, and there may be guidelines from the state on how we handle high-risk employees, but we don't want to, again, in making our recalls, make presumptions about who is higher risk and have some sort of discriminatory impact in that selection. And then once you get ready to do this, provide recall notices to employees. Let them know what your plans are. Give them a couple weeks notice so they can plan to get back to work. They may have family obligations. They may have family members with COVID. So they may have acquired a disability while they were deciding to be really active while they were off work and learning new talents, and they may have injured themselves. So things may get in the way that way of getting them back to work. Once you are recalling them back to work, it is an affirmative obligation that you notify the unemployment of the employees recalled. Whether the employee decides to come back to work or not, notify the unemployment department that you have recalled them and they have a job opportunity and they are reporting to work or chose not to come back to work.
This is really nothing new. We have received a lot of questions from clients and others. I've gotten in touch with Gridley. I've told them it's time to come back to work, and Gridley has said, I really enjoy receiving this unemployment pay plus the extra $600. I'm not going to be coming back to work. Well, the fact of the matter remains that it has always been an obligation on an employer, unrelated to COVID-19, to report to the EDD any change in an employee's status who is out on unemployment within 10 days of that change. That's always been the case. And in fact, as Donna indicated, it is an affirmative obligation on the part of the employer.
Okay, so as mentioned, there may be reasons that you don't get your employees back to work right away. But assuming they're coming back to work, let's get into some of the safety communications that need to occur. So you want to make sure that employees and customers feel that they are welcome and safe at your place of business. That's how you're going to get your employees back. That's how you will get customers to start frequenting your place of business. So think about your workplace safety, cleaning, and disinfecting procedures. It's probably going to be something more even than it was before. Temperature and health screening. A lot of questions on that, and that is something that we can do only for the duration of the pandemic. This is not a forever new practice.
It was an issue that came up early on in our counseling on the COVID-19 pandemic. Can we take the temperature? Can we ask about coughs and shortness of breath and other health screening questions? And the guidance from the EEOC on a very regular basis is these are questions that you cannot ask. However, the EEOC has made an exception for the COVID-19 pandemic. That's not without history. They've made exceptions in the past with SARS and MERS in the past. But keep in mind, asking these health screening questions and taking temperatures only lasts for the duration of the pandemic, as is indicated on the slide.
Correct. And of course, also, we've heard a lot about social distancing or physical distancing. You need to make sure that you address that in your workplace. And any requirements for personal protective equipment, such as masks or gloves. If you require those in your business, then you need to either provide them or reimburse employees for providing their own personal protective equipment. It can be something that you choose to make optional. Any of these things on the list are simply recommendations for you to consider, not requirements. But think about your traffic patterns. We've all seen those markers in the grocery store of the, walk this way sort of thing. You may or may not find that that's helpful in your place of business. Also think about occupancy limits in certain areas where there might be larger groups. You may reduce those limits. You may change your hours of operations, either reduce the hours so you have greater time to do the sanitizing, or increase the hours so there are fewer people there at any given time. And then also you may choose to have some entrance restrictions. If you're doing some of this temperature and health screening, you may want to funnel everybody through one particular entrance. So as we continue into workplace practice adjustments, of course, we're going to have a new normal or a new unknown, depending on what it is. So we talked about the temperature and health screening. In terms of the physical distancing, think about your workstations. Do you need to separate those or put some of the plexiglass barriers between cubicles if there was no barrier before to separate people a little bit more than they were before? And then think about your staffing levels. Do you put the same number of people in the place that they were in before, or do some of them still telecommute so you have less there at the same time? And then also your meeting room capacity. Maybe it used to be a meeting room for 15 and now it's a meeting room for 6, so they can be spread around the room. Assess what's correct for your work environment. And then work schedules are another thing to think about. So they could be modified. You can do some temporary transfers to the extent they don't create an undue hardship. But maybe you stagger work schedules. Maybe you have half the people in the office on Monday and Wednesday and half the people in the office on Tuesday and Thursday, and they're working remotely the other days. Maybe some are in the office in the morning and some in the office or in the facility in the afternoon. Whatever works for your business and creates that safe place where employees feel comfortable. Then also think about your lunch and break rooms. That's another place that employees might congregate, as well as like your smoking areas, wherever employees might congregate. Do you stagger breaks or lunch schedules so everybody doesn't congregate at one time?
And let me note that with respect to staggered shifts, rotating days in the office, telecommuting arrangements, and we'll get to this in more detail later on in our program today, but the Division of Labor Standards Enforcement has made next to no modifications and allowances for suspension of laws and regulations as it relates to wage and hour here in California. Full compliance is still expected.
Absolutely. And then, of course, on business travel, determine what is appropriate for your business and what are the safe practices for your employees if they're traveling. And customers, visitors, establish a protocol for how they might enter the business, what the greetings might be of coworkers or visitors or customers. Probably the traditional handshake is not the right way to go. So something that is touch-free in terms of greeting people would be something that might make them feel more comfortable. And then also think about the ventilation or air purification in your workplace to, again, make employees and customers feel very comfortable that it is sanitized and safe to be there.
What about recommended programs, Donna?
As we continue to think about bringing employees back, you may appoint an employee or get a consultant who is responsible to ensure that the policy and the operational practices are implemented as they evolve. As we talked about up front, the expectations on what you can and can't do seem to change at least hourly at this point in time. So it's something that you need someone in your company or an outside consultant to monitor for you and say, now you can do this and now you need to do that. And I think there may be some back and forth as we've seen so far in regulations. So select someone that will focus on that for your business. When you modify your policies or your protocols, such as maybe we're going to take temperatures on the way in, you probably want employees to sign and acknowledge that they know this is the new protocol in your business. And subject to guidance otherwise, you can provide the personal protective equipment, like we talked about, masks or other things along those lines, or reimburse employees unless it is mandated, of course, by our government. And then continue, for those that are temporarily laid off, continue communication with them. Let them know, as we said, your plan that, in a couple weeks we're planning to bring some of you back and the rest of you will have communication 2 weeks later. Whatever that is your business plan. Stay in contact with those employees so that they know that they are still likely to be recalled to your business. If at some point you decide our business has changed and we don't have the same volume of business that we had before, and we're only going to need X% of our employees, and also communicate to the rest of the employees that you will not have opportunities for them.
So there are a lot of changes that are going to happen in the workplace. Let's talk about some potential policy changes that, in fact, may not be obvious.
Yes, and again, these are things you can think about. They are not required, but you may think about your paid leave policies to fit your new business needs, including those things around sick leave or attendance policies. Now we're saying, okay, if you have any symptoms that might be of concern, we don't want you to come to work. At least most employers are starting to think, okay, if you have a fever, please call me, don't show up at work. It may be something unrelated to COVID-19, but if you've got some minor ailments, we'd rather you stay at home than come into work. And so our prior attendance policies at many companies might have said, three sick days and you're going to get disciplinary action if you're absent more than that. So think about those policies and whether they're right.
Let's also keep in mind that these changes that Donna has been talking about, these are, of course, are in addition to the requirements for the under the FFCRA, the expanded family medical leave, the emergency paid sick leave, and under the, like I indicated, the FFCRA. Those continue on in place. They will continue on in place until December 31 of this year, and it is not apparent at this point that the ending of that is tied to anything other than December 31st, meaning that if the pandemic completely subsides, those leave rights are still in place.
Correct, and those leave, the qualifications to take that leave are related to COVID-19. So if the pandemic were to end, it would be hard for an employee to qualify for those leaves because they are not suffering from COVID-19. As we continue on this list, we did talk about the flexible start-stop times and the alternative work schedules and staggering meal and rest breaks. As we talked about on the alternative work schedules, you still have to go through the formal process to establish an alternative work schedule. Nothing has changed, allowing more flexibility for you just to decide that you want a 980 or a 410 or some other alternative work schedule. You've got to go through the voting process.
Keep in mind that makeup time has always existed. It's existed since about the year 2000, and so that is an alternative that you may want to consider for your employees. That having been said, as Donna indicated, there is no exception if you want to work on a 980 schedule or a 410 schedule because that fits better with the imperatives created by the COVID-19. You still have to go through the whole voting process, and that actually takes a fair amount of time.
Yes, it does. So that's something for you to be thinking about here in advance if you're wanting to do that, plan ahead for that. And then telecommuting, many organizations allowed in this emergency sort of situation some more telecommuting than ever before. And you may decide that you want to develop a telecommuting process on an ongoing basis that may be different than what it was on the emergency basis.
Molly, it looks like we have a question that has come in at 12:25.
Yes, someone has asked, can I legally in California require an employee to go home if the company believes he or she is sick, experiencing COVID-19 symptoms?
Really good question, and the answer to that is yes. And this is nothing particularly new. If you see an employee, if an employee reports with symptoms, then you can send that employee home and ask them to obtain certification from a healthcare provider, and then they can return. But otherwise, it's the same as it was before. If you have an employee before who is exhibiting symptoms, food poisoning, they're throwing up or doing whatever, count on me to give you the dramatic example, right? You can send them home. Donna, any thoughts on that?
That is absolutely correct. The only thing that has changed is that those individuals who are not exhibiting symptoms, but say they were exposed to someone with COVID-19, they are no longer to be sent home. Just monitor their symptoms. If they develop symptoms, then they would go home. But if they're symptom-free, keep them at work.
Now, there have been some specific developments actually announced just yesterday with respect to workers' comp and rebuttable presumptions. This program, I might note, is not about workers' compensation, and we will be touching on this only lightly. Donna, what's in this latest executive order from the governor?
Well, this is a temporary order pending actual implementation of a more permanent rule on this. So temporarily, for employees working between March 19th and July 4th of this year, because we're waiting for publications of the actual order, there is a rebuttable presumption of the illness or injury arising out of work. That may or may not stay rebuttable, which is, you can actually say maybe they didn't contract COVID-19 here at work. They might have got it, from their parents that lives in the home with them or somebody else. So it's around the COVID-19, and a positive test is required. It applies to all workers outside of the home, not remote workers, obviously. So they're working at the office or the factory at the direction of their supervisor. And what it's doing is reducing the time to file the complaint and to respond to the complaint from a typical workers' comp sort of claim. So there's certainly more to come in this area of an actual order and exactly what that will entail. But for the short term here through the 4th of July, at least we have this temporary rule that's really going to tighten up that timeline in terms of filing a workers' comp claim around COVID-19 and responding to a claim around COVID-19 for workers' comp.
How about compensation? A lot of folks have been, employers have been offering hazard pay or some kind of COVID-19 show-up pay, a couple dollars per hour. We've heard about Amazon doing that. Might note that there's nothing in state law or federal law that requires that. Might also note that if you have a collective bargaining agreement, if you do want to make any change in pay, up or down, that is a subject of mandatory bargaining. But there's nothing in state law at this point that requires that if you have increased the compensation to employees, that you have to continue to do so, save and except the fact that you can't do that retroactively. You can only make a change in pay prospectively if you're going to be reducing it. Payment for health and temperature check time. If it occurs at the workplace, it's done for the benefit of the employer, and that has to be compensated. So just as waiting in line to clock in is something that typically has to be compensated, or waiting for the computer to boot up has to be compensated. If you are asking the employee to take their temperature or fill out a health questionnaire, that is compensable time. Missed merit increases, Donna, some of that's been happening. Tell us about that.
So if individuals in your company were getting merit increases, say on their own anniversary date, and some employees had their anniversary date happen here in March, April, May, and they've been off work, and so those merit increases were not put into place. You might decide whether you want to start those merit increases upon their return, make them retroactive, how you might handle those individuals. If you have merit increases on a common date, and let's say that common date was in April, maybe your common date changes, maybe your business has changed such that you don't grant it in 2020. So it's just something to think about around how you handle merit increases.
Keep in mind, I just want to throw this in, today's program is being recorded, and the various slides and the recording will be made available to attendees within a couple of days.
Okay. In addition to those merit increases, on the other side of that, you need to decide if pay cuts are needed. If you implemented something during the pandemic, you may need to reverse something. You may need to just do pay cuts across the board because your business has suffered economically. So as you're doing those pay cuts and as you're changing people's jobs as they come back to work because maybe you didn't get everybody back, maybe the business has changed, think about whether they are now exempt or non-exempt. particularly whether they meet that salary standard for exempt, whether their role has changed to make them now non-exempt, and also will they be full-time or part-time, which may be different than they were prior to the pandemic. Bonuses may be impacted. The other thing is it's a great time to proactively look at pay equity, look at your systems, your structures around pay, and get everything just as in order as you can as we're restarting things.
Telecommuting. Many of our clients and others have begun telecommuting for their employees, and some have come to the realization that telecommuting is a wonderful thing. On the other hand, some have come to the realization that telecommuting just doesn't work, but it is a little bit of a reality. Let me suggest this. We are closely monitoring moves coming out of Sacramento. There is a possibility, although we have seen nothing in this regard, nor have we heard any whispers about it, and I don't mean to suggest anything, but there may be a telecommuter's Bill of Rights that comes out that allows employees under appropriate circumstances to work at home. Stay tuned in that regard. We have some information coming up that the EEOC has uniformly taken the position in the past that telecommuting is not a reasonable accommodation, but stay tuned. In any event, remote timekeeping can be a challenge. Timekeeping is still required of employers to make sure that the employees maintain a record of when they start work, when they end work for a meal period, when they start up after meal, and when they end their day. You may want to check with your payroll provider, or if you do payroll internally, take a look. There are various apps that go right on the computer or right on a smart device for remote timekeeping. Just because someone is telecommuting, they're still entitled to take rest and meal periods, and you as the employer are still required to give them a reasonable opportunity to do that. Practically speaking, determine how you're going to avoid interrupting an employee's rest break or meal period. That may be as simple as having the employee send an email out saying, I'm now on my rest break or my meal break, and then send another email when they are done. And certainly advise your employees who are telecommuting to not answer the phone while they are on a rest break or a meal break, as the case may be, because that will interfere with their right to take the rest and meal periods. There should be an expected work schedule so that when you call Gridley at home, Gridley will be there. If there's not an expected work schedule, things start to fall apart and get really fuzzy. Keep in mind that overtime is still there, and daily and weekly overtime, there is no exception. There's no COVID exception to that. That still applies. Travel time, interesting question. For telecommuters, we all know that in every circumstance prior to COVID-19, of course, the commute time to the regular place of report is not compensable. What happens if the regular place of report changes? Well, you need to pay for that commute time. But we do know that the commute time from the kitchen to the home office or from the bedroom to the home office, in fact, is fairly short. So there's no obligation to pay for that commute time. But let's also consider that if the home becomes the regular place of report and the regular place of work, then asking an employee to come into the office, in fact, is compensable. and subject to expense reimbursement. That having been said, that leads us right into expense reimbursement. And this gets into, we all know about cell phone reimbursement since it's no longer on a per call basis. People have large data plans, and sometimes they even have family data plans. And so the practice, which is perfectly acceptable, is to provide an agreed amount to reimburse an employee for usage of their cell phone. Alternatively, the employer might want to use software such as we have here to forward calls to employees' business cell phones, forward calls to the office, to the employee's home phone or the employee's personal phone. And of course, if it's forwarded to the home phone or the personal cell phone, there are going to be reimbursement issues there. The little swampier area that we really haven't had to contemplate in the past is for those telecommuting employees, how much reimbursement do we have to make for accessing the family's internet? How much do you have to reimburse for that? How much do you have to reimburse for electricity at home? If that person lives by themselves, they wouldn't be home during the day running the air conditioning. There's a reimbursement issue there. The gas, the electricity, and maybe supplies. So it's all going to be based on, and the reimbursement for those is going to be based on necessity and reasonableness. There is no one suggesting at this point that you try to parse out how much of the electricity bill is owed by the employer because it was incurred only because work was being done at home. But these are things to think about, and something that employers might give consideration to is allowing telecommuters an allowance, a reasonable allowance, for the use of the home electricity, the home internet, the cell phone, etc. Other wage and hour issues in the telecommuting area, split shifts, on-call status. These are more complex areas that we just raise at this point, and we won't go into further detail on. Other issues, wage and hour laws, and this is an interesting little thing, and that is we know that employers may have employees that come to work in Kern County, but they might live in a jurisdiction where there are local wage and hour laws.
Correct. So the location in which the employee works, which may be their home office, is where the wage laws apply. So if they live in Orange County and they work in Kern County, but now they're working at their home office in Orange County, there are different minimum wage requirements, different sick leave requirements, could be some different overtime requirements. So you need to be aware of where they are actually working if they're telecommuting, because you may have different obligations in those areas.
This is a tricky area, and let me just say, for example, if you have an employee living in Palmdale, Lancaster, but working in Rosamond, okay, there's a county line in between those two. If that employee is now telecommuting from Palmdale, Lancaster, they get the benefit of the wage and hour laws that have been implemented by LA County. Off the clock work, nothing new here. There never has been such a thing as off the clock work, but with respect to telecommuting, it becomes a little bit more difficult to monitor. Benefits impact, and we're going to need to start moving through this fairly quickly. So Donna, hit the highlights for us on benefits.
Yeah, so employees having been off work could have some impact on their benefits in terms of health insurance, if they're a rehire, maybe some eligibility issues, waiting time issues. Also, your flexible spending account, if you haven't had child care expenses for the past couple months, how does that impact your FSA account balance? Can you have some allowable time to claim that? Your 401k or pension, look at the eligibility due to layoff and maybe the break in service, how does that apply to counting years towards the next contribution level? How does it affect loans and payback? These may all be different in your business and your benefit carrier. And also look at your paid leave provisions, particularly as we talked about around the FFCRA leaves, and see if there are any changes in paid time off or holidays that you want to do given the time away from work.
Eligibility issues?
And this is certainly related. So again, maybe you had a full-time employee that became a part-time employee during the last couple months and then wasn't eligible for health insurance. Take a look at that, review your other benefit plan enrollment that may have been impacted by those changes in schedules or the layoff that the employee was subject to. If an employee returns to work from a furlough or layoff and they've been gone less than 13 weeks, they need to be allowed to begin participation in the employer's health care plan immediately upon reinstatement with no waiting period according to the Affordable Care Act. For other benefits, you can do new elections.
So paid sick leave, for those of you who have just the mandatory paid sick leave under the state of California, of course, you didn't pay out the balance, or at least you weren't required to pay out any MPSL balance if you placed an employee on furlough, layoff, or actually terminated them. However, keep in mind that if an employee comes back to work for you within the year, they are entitled to reinstatement of whatever balance of paid sick leave existed when they left your employment. Keep in mind, again, certain California counties and cities have different paid sick leave ordinances, and if the employee generally, the general rule is works at least 2 hours per week in that other jurisdiction, they are entitled to those paid sick leave benefits of that jurisdiction. Reinstated employees, they aren't subject to the same eligibility requirements as rehired employees. This gets a little bit into the weeds, but just understand that, and this deals more with the I-9 that we'll talk about in a moment, but keep in mind that when you are reinstating employees, there could be some special consideration. Employee status recall affects recall. Generally speaking, employees on furlough or layoff, you bring them right back in. If someone has been terminated or as a result of either disciplinary issues or a reduction in force, and there's been a severance of the employment relationship, the conservative advice is to take them through the entire rehire process and documentation. So what does that mean, Donna, new hire paperwork?
So certainly, like we said, if they're reinstated, you don't need to go through the whole new hire process. If they are being rehired, and you can decide what that break-in time is that constitutes a rehire, then you can go all the way through the normal hiring process in terms of application, benefits, I-9s, background checks, drug screens, the complete new hire paperwork process. And you can decide on your layoffs if they were complete separation of employment. Many of those could be a reinstatement. Certainly those completely terminated would be a rehire, and anybody new, of course, has new hire paperwork.
I-9s are sort of a little bit of a treacherous area. Donna, what are the basics here?
Okay, so the highlights on the I-9, again, if you're rehiring an employee that was just there a few weeks ago, Do you have to go through the whole I-9 process again? No. No is the answer. So let's say they've just been gone for 6 weeks and they are being rehired. You don't have to do the whole I-9 process. Make sure you have the current I-9 form if you are hiring or rehiring somebody versus reinstating somebody.
Let me throw in the lawyer's caution here. If you have suspected that Gridley is not authorized to work in the United States, and you want Gridley to fill out an I-9 form, lay down, take a rest, and get over the urge. This is not the time to try to trip up Gridley on his work authorization status, and especially not in the state of California. There are protections for employees in this regard, and using a COVID-19 layoff or furlough as an excuse to require Gridley to recertify, it will be viewed, shall we say, dimly by the state of California. Completing the I-9 form?
Yes, so if you are relying on a previously completed I-9, so you're reinstating that employee, if nothing has changed in their employment authorization status, their I-9's fairly recent, there's no further action required. But you just need to fill in the rehire date on Section 3, sign and date the form, you're done. They're rehired, reinstated. If their authorization to work has expired, then you need to re-verify the employment authorization in Section 3 and provide the rehire date. If in doing that Section 3 update, your I-9 is not the current version, complete Section 3 on the current version of the I-9 and attach it to the old I-9. So that's how you update the I-9 if you're completing that section.
Now,
if it's already been used on that form, again, attach the new form.
one of the questions that we get from time to time is an employee says, I'm immunocompromised, I'm a member of a high-risk group, I'm over age 65, I don't want to come back to work, I fear getting COVID-19 if I do come back to work. A couple of comments on that. Number one, the standard that we are informed by from OSHA, Cal OSHA, is that fear itself does not create a reason to not come back to work. And in fact, to the contrary, an employee must demonstrate that there is a reasonable and imminent likelihood of severe injury or death if they do return to work. That's a fairly high standard. Having said that, and Donna's going to talk about this, if you do have employees who are in high-risk groups, age, immunocompromised, etc., this is where reasonable accommodation comes in, and further leave may not be a reasonable accommodation. It may be something else.
Absolutely. So if someone actually has a disability, you're looking at a reasonable accommodation. And the EEOC was helpful to employers in this situation as recently as April 17th and talked more about an undue hardship. So you may have some different situations than you had prior to the pandemic in terms of your cash flow, in terms of what you have in your business in terms of accommodations and what staff you have available to assist somebody with some limited capabilities of things that they can perform. So with all those things said, you may have situations that you cannot provide an accommodation now that you could provide before the pandemic, but it doesn't get you completely off the hook for assessing what a reasonable accommodation is. So if there are those individuals that have immunocompromised situations, look at whether it's an appropriate accommodation to maybe have them work in a separate work area or telecommute or something else appropriate for your business.
Now, from a business planning perspective, the business is probably best advised to anticipate communications that they might want to make or might be asked to make.
Yes, so prepare in advance that you probably will have an exposure of an employee or relative of an employee, and think ahead for those communications, internally and externally. So externally first, hey, we're reopening, this is what we're doing to make everybody safe. Have that communication ready to show how the business is supporting workers. But then when that exposure may occur, have a communication ready for internal use and have your procedures ready and have a media response ready as well. So you are just not scrambling if something like that happens unexpectedly in your business.
Keep also in mind as we begin to move things to a close here, if you do have telecommuting employees now and in the future, keep in mind that there will be security issues, as there always are security issues when it comes to shipping information through and receiving information through the internet. Make sure through your internal IT department or your IT contractor that if you do have an employee who is telecommuting, that everything on their end of the connection has all the security that you would normally require. We have been reminded from time to time throughout the pandemic that there are folk who are taking advantage of telecommuting and the risks and weaknesses that arise in that regard. Keep in mind to be aware, and this is just sort of a in the area of harassment and so on, to advise your telecommuters to make sure that their home workplace is free and clear of anything that might be considered to be harassing, that they wear proper attire during video meetings. I'm sure as we move through this, there will be plenty of YouTube collections of showing massive disasters when it comes to Zoom calls.
We've
Telecommuting.
already seen the ones out there of they wore the suit top and not the rest.
And no pants. That's right. Let's see. Just keep in mind that workers' compensation insurance must cover remote workers. There's nothing about working at home that says that workers' comp doesn't apply. This may cause you to want to conduct a home inspection. That's a little bit of an area that's some telecommuters buck up and say, I'm not going to allow that to happen, but you do have a right to do that. Also keep in mind that if Gridley shows up to the Zoom call a little bit tipsy from having begun the evening a little bit early, drug and alcohol policies certainly apply to remote workers. Successful companies are those who are going to be doing the deep thinking on telecommuting and on how they bring back the employees. Video conferencing certainly has existed. Zoom has existed since 2011, but people are making so much more use of it now, but it's something that you might want to integrate into everything that you do. Also support workers through the changes that occur, show empathy, build trust, provide advance notice, understanding that employees will need time to prepare to transition back, childcare, equipment back to the office, etc. It's all about trust, folks. That's what it is. It's all about trust. And there is hope for the new normal. Molly, we have an opportunity to take a couple questions very quickly. Can you read the question to us from MP at 1256?
Yes, this individual has asked, once we hit phase 3, opening offices, If we have an employee who states he or she is immunocompromised and cannot return to work in the office, can we require a doctor's note that says he or she cannot work in the office?
Absolutely. As with any disability, you want documentation from a healthcare professional of the restrictions that the individual has. And the company can have that interactive process with that employee to determine what a reasonable accommodation is. A reasonable accommodation might not be staying at home. A reasonable accommodation might be we put you in a private office with a door, with an air purifier, and that's a reasonable accommodation.
The interactive dialogue cannot take place in the absence of knowing what the restrictions are. And so this is one of those areas where that needs to be known and that needs to be discussed, because otherwise the interactive dialogue cannot take place. Molly, one more question from JW at 1250.
Yes, this individual has asked, if prior to an employee observing the stay-at-home order was part-time, and at the time of coming back to work after the stay-at-home order is lifted, the employee had meanwhile decided that for the best interest of the organization, all employees will be required to be full-time. Can the employer require the employee come back as a full-time employee? The employment is essential and the employee did not close or send the employee home.
The short answer to that is yes, as long as it's done on a non-discriminatory basis and there's a business reason for doing so. There's a lot of facts that are packed in there, but that's sort of the general advice to be given. Finally, the governor has, it appears that the governor has largely reiterated the announcement that he made earlier this week. Shopping retailers will be allowed to reopen. Associated manufacturing plants will modify their workspaces to allow for social distancing and PPE. More industries will gradually reopen as we progress further into stage 2. Offices, seated dine-in restaurants, shopping malls, and outdoor museums will be opening later. They are not yet authorized to open. And training employees will also, it appears, be required. Detailed risk assessments, limiting and how to limit the spread, how to screen for symptoms, and stay-at-home facts. So more to develop as we go through this. Molly, thank you, and please take us out.
Thank you for attending today's program. We appreciate your attendance. A copy of these slides will be available following in the next couple of days. Thank you. This